Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Stephen T. Northcutt, Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning. Welcome to the Valentine's Day session of the second DCA. If you represent the appellate, remember that you are entitled to reserve some of your 20 minutes for rebuttal. And if you'll let me know how much you want to save when you come to our virtual podium, I'll try to give you a heads up when you get there. So I think our first case is Owens versus Oleksiak. So you made it, Mr. Brannick.
Good morning. Sorry for the technical difficulties.
You're not the first. Okay, Mr. Blonsky, you're up.
Thank you. May it please the court. Daniel Blonsky of Coffee Burlington on behalf of Appellant Morris Owens. I'd like to reserve 5 minutes for rebuttal. It's nice to start this Valentine's Day calendar with a post-divorce dispute. This appeal calls for a de novo review of the trial court's misinterpretation of a one-sentence section in a final judgment of dissolution of marriage. Specifically, Section 5 of the final judgment in its entirety reads as follows. The wife shall have sole control of the 529 plan previously established, and the assets and income of said plan shall be used exclusively for the benefit of Alec Mickles, who's the grandchild of Mr. Owens, but not of his ex-wife.
Well, wouldn't sole control give the right to turn down some of the expenses if need be?
It would give right to turn down some expenses if need be. We don't dispute that. The issue here is it's not an unfettered, irrational, unjustified right.
Well, Mr. Blonsky, am I correct that there was no evidence taken at the hearing below?
Well, there was no evidence taken because the ex-wife failed to respond to discovery. She, in the record, is her failure to appear at a properly noticed deposition. She didn't attend the hearing. Her counsel did not attend the hearing. So they submitted nothing. So it's sort of ironic to be castigated in the briefs about not presenting evidence when she refused to comply with her discovery obligations and has not put forward any basis for her refusal to disperse funds that are unquestionably qualified educational expenses that would benefit the grandchild. There isn't any record evidence put forward by her because she didn't respond to anything. So it's undisputed that it's unchallenged. Pardon me?
And to follow what Judge Northcutt was saying at that hearing, and I recognize the fact that the other side did not show up, was there any showing from your client or from you that given this provision regarding sole control, that these are appropriate funds, these funds are appropriate for his education, anything whatsoever to be provided to the judge in order to grant your request?
Yes, Your Honor. Exhibit B to the motion attached the list of the items that made up the $15,000 plus that were the subject of the motion. And they're all laid out with specificity as to what they are. They are all within the definitions under the 529 statute, qualified educational expenses. They're tuition, room and board, school funds. So that's also not disputed. I haven't seen anything in the answer brief contending that the items that were submitted to the ex-wife, who's a trustee of the plan, were not qualified. If she'd made a determination, a reasonable, good faith determination, they're not qualified, that would be within her sole control. But she didn't do that. There's no justification. The record shows she's never given a reason for her refusal to pay qualified educational expenses for the benefit of the grandchild. So,
and this is what University of Hawaii, was that an issue the fact that it is like out of state or it's in a different place, an exotic place, was that, I don't know if that played an issue in this matter?
So that has not been articulated as a reason that some anti-Hawaii animists, which I would suggest is not a good faith basis, but that wasn't articulated. And the record indicates that there were prior payments. The ex-wife never made payments for room and board, but she did at some point earlier in the grandchild's education, did approve some tuition payments, and then she stopped. And that's what led to the motion that was denied by the trial court, is she stopped entirely and stopped communicating, just went dark. And that's not permitted in our view, and is a violation of the final judgment, which the court.
And I appreciate that, but then circling back, then was it your burden, Mr. Belosky, at least at that hearing, to show? I realize what you've attached, and I see it right here. But wasn't it your burden at least to make an evidentiary showing to the court that these are appropriate expenses? That you've already shown that she has refused to pay. Don't you bear some evidentiary burden to provide that information to the court?
So I believe that burden was met at the hearing by the submission of what the expenses were. And again, it's a little hard to establish the position of the ex-wife when she doesn't comply with discovery, but we did put forward what the expenses are, and we did submit and make argument and follow the statute to show that those are qualified educational expenses, and that there was a submission to the ex-wife. All of that is of record, not challenged. I believe there's also a filing of the email exchange or email directed to the ex-wife by the grandchild's mother, which there wasn't a response to it, but again, asking about this. So I think we've met our evidentiary burden, recognizing that there's only so much we can do when there's no cooperation from the ex-wife. And the problems with what the ex-wife did were apparent to the trial court. What the trial court did is it focused exclusively on the sole control language and ignored the specific control limiting requirement that the assets and income of said plan shall be used exclusively for the benefit of the grandchild. And what the trial court did is it sort of threw up its hands and said, and I'm quoting from the transcript, "I don't necessarily think it's right that Ms. Oliksek is not paying these fees, that she should be, but she has sole control of the amount and she gets to make that call." And the problem with that is it doesn't harmonize the sentence, the section. It just looks at the beginning of it, which is the position that the ex-wife has taken, that she has sole control. She can do whatever she wants. She doesn't have to justify herself, doesn't have to articulate a good faith reason, even though good faith is endemic in here. And that's simply the reversible error, that we don't get past the first part of the sentence to get to the second part and do what the section is intended to do, in which the trial court recognized is the intention of the section, which is to pay qualified educational expenses. So it's the ex-wife's call to decide whether this is a qualified educational expense or if there's sufficient funds. There's no dispute on the record that the amount of funds available in the plan was far in excess of what was being requested. This record shows over $100,000. This is a $15,000 request, though sadly the amounts she's refused to pay have increased in the year since this, 363 days since that hearing. But what's happened here is she's been allowed to really flout her responsibilities as a trustee that were placed on her in the final judgment. And the court hasn't enforced its final judgment, which it recognized as not being honored. It just said, "This is not what I can do." And respectfully, we cite a whole host of cases that say the court is authorized to enforce its final judgments. It is entitled to and is empowered to give meaning to the entire final judgment and marital settlement agreement that was approved by the court. And that didn't happen here. The court knew it didn't happen, but it didn't think it was empowered to do so. And it clearly is. This is a court order. It's a final judgment. The court can enforce it. The court should enforce it. And to allow the money to just sit there not being used for qualified educational expenses is not the order of the court. They shall be used. That's mandatory language. And it places an obligation on the ex-wife. It shall be used. That's not discretionary to her. They must be used if they're qualified educational expenses and there's money there. Those things are undisputed. These are qualified educational expenses. This isn't, money to join a social club. These are school expenses that fit under 529. And she doesn't have the right to say, well, I'm just going to leave it there, run the clock out on your education, and leave $100,000 that I can then make a claim against. That's not her right. She hasn't set forward any reason, despite being called to deposition, for why she refused to fund qualified educational expenses. That's a violation of the final judgment. And the court should have made that finding. Because she did not defend, I think that's the end of it. If it's determined that she has a right to cut up a defense a year later as to why she didn't do it when she didn't come to deposition, then I guess there should be a remand for a factual finding. But I really think that ship has sailed when she failed to show up for deposition or at the hearing or articulate for a year and counting any reason why the money's sitting there in the account as the grandchild is now approaching her graduation. So, on this record, knowing that the ex-wife refused to participate and really only came to action once this appeal was filed, we're in a posture where there's a final judgment that requires money to be used, shall be used. It didn't happen. She has a good faith obligation, that's undisputed. She hasn't articulated good faith. There isn't any apparent good faith when this is a college, University of Hawaii. These are legitimate expenses. And, sometimes after divorces, people make irrational decisions, but they should not be justified by sole control language when there's still a mandatory obligation to use the funds in accordance with the mediated settlement agreement and the order that enforced it, the final judgment. So we ask at this point that there be a reversal and a direction that the final judgment be enforced by having those funds sent out of the 529 plan by the ex-wife in her role as trustee and reimburse what was previously submitted to her from the 529 plan.
Mr. Blonsky, let me ask you this question. This was done by motion rather than petition. So it's not like rules of pleadings that apply to it. And I ask this because there's no risk, no answer to a petition, so there's no default or what have you. What do you anticipate if we were to reverse? What would the status of the case be? What would the posture of the case be if we sent it back? What would happen next?
So there is another post-ruling motion petition that was filed to modify. That is pending. I think there was a motion to dismiss filed, hasn't been ruled on. It's not in the record, but it's my understanding that there was a petition to modify, which was directed, I believe, towards removing the ex-wife in her trustee capacity. But with regard to this appeal, I believe what the posture would be that she's directed to, the court would be directed to enforce the final judgment and require her to use from the 529 plan the funds that were sought in the motion.
Okay, and you've mentioned, and I tend to agree, there is an obligation of good faith. We don't know what her reason was because she hasn't responded. So were there efforts below to compel her to respond to discovery, to appear at a deposition or what have you, so that the court could hear her version of her side of things?
So my understanding of the record is her deposition was scheduled for shortly in advance of the hearing on the motion to enforce the final judgment. I believe it was the same week. She did not appear. The certificate of non-appearance was filed. Might have been the week before, but within a week or so.
Yeah. There was
that's
discussion of that at the hearing. I saw that in the transcript.
correct. So I do not believe there was written discovery. I think the effort to take discovery was the deposition. She didn't attend. There wasn't a time window in which to move to compel, given the pendency of the hearing. So that was just presented to the court that we tried and failed.
So but the judge's view, I get reading the transcript and looking at the order, was that really that didn't make any difference because the judge felt that sole control meant she had sole discretion, sole authority, what have you, and that it ended there. So she didn't really need to give a reason.
That's my reading of the transcript as well. If she'd shown up for deposition and said, I didn't release the funds because I don't want to, and my reasons are personal and it doesn't matter, that would have satisfied the inquiry that the trial court undertook. And it's our position is that's an erroneous inquiry. It's a legal error to give her carte blanche to not have a good faith basis for what she did. That's not what sole control means. It doesn't mean
We don't know what she would have said. You're projecting onto her sort of an arbitrary motivation. She might have had some other motivation.
But for sure, my point, Your Honor, was just I don't think it mattered to the trial court.
What I'm saying,
she had a good reason or not.
That's what I was pointing out. The court seemed to believe that the phrase sole control ended the inquiry.
Right. I agree, and I think that's the error we're
right.
Focused on.
We are at your 5 minutes remaining, Mark. So
if there are other questions, then I'll just save the rest of my time.
Okay, Mr. Brannick, you're up.
Morning, Your Honors. May it please the court. I'm Steve Brannick of Brannick, Humphreys and Berman here for the appellee, the former wife, Linda Alexic. The trial court was correct and simply enforced the plain language of the final judgment in the parties' agreement. The language is straightforward. The wife shall have, quote, sole control of the 529 plan previously established.
But do you disagree? Do you disagree that she has an obligation of good faith?
I don't have any disagreement about that, but there is no evidence in the record or no allegations other than the bare statement that her refusal was arbitrary. There's nothing in the record to suggest that she acted in bad faith. All the record shows here.
Would you also agree, though, that the lower court didn't seem to care one way or the other what her motivation was because she had sole control?
Well, it wasn't just the lower court. This is if you look at the record at 328, the judge says this is going to involve pure legal argument, it involves the interpretation of the plain language of the agreement, and opposing counsel then says, Judge, we agree with your view. The judgment is very straightforward. They chose.
There would have to be some obligation of good faith. Otherwise, there's nothing to prevent the individual from just turning down any and all requests for reimbursement, and then there would be no recourse.
Well, absolutely, Your Honor. But the only allegation in this record was that the former wife refused to fund one particular request. That's the only allegation here. It's alleged that request, that refusal was arbitrary, but that was not accompanied by any allegations of any kind demonstrating why it was arbitrary, and it certainly wasn't accompanied by any evidence on the record to demonstrate that what she did was arbitrary. They are arguing that she has the obligation to fund every single request, regardless of whether she thinks
reading the judge's order, it sounds like he's of the opinion that she could agree to fund no request.
Again, we never got to that point in the proceedings because they elected to go forward on an argument in their complaint and then an argument at the hearing that she has the obligation to fund every request, and all they showed was that she refused one particular request. If they thought that it was important to demonstrate that it was arbitrary, or that she had acted in bad faith, or that she had refused a series of requests, then they certainly could have alleged that in the complaint. They did not. They certainly could have proffered that evidence to the court. They did not. They could have asked for leave to amend the complaint. They did not. They could have asked, Judge, we need to take her deposition so we can understand exactly why she's refused to fund this request. They did not. Instead, they chose to rely on the the pure legal argument that she has an obligation to fund every request. The judge then asked, "Do you have any legal support for that?" They didn't provide any legal support. So on this record, this very simple complaint that's based on the plain language of the agreement that gives her sole control. Sole control means that she can choose to fund or not fund a particular request. And that's all that's happened here. She chose not to fund a particular request. So
So if I can understand you, Mr. Brannick, if instead in their request, and it's interesting what Judge Northcutt raised, that this was done by motion as opposed to petition, but let's just assume that posturally it's well before the court. If their petition, and if it's a petition, and if they would have alleged that, number one, there's been a failure for her to pay in the past, that this is legitimate, this is what's in the best interest of the child, this is something that the child's making a request, and if they teed it up that way, do you think that would have been sufficient for the court to make a determination?
I think that would have made for a much more interesting case, but I think that still would have needed to have been accompanied by some evidence of some kind, evidence from the language of the 529 plan. What does the 529 plan say about this? We don't know, because that was never submitted to the court. What does federal law say about this? What does federal law that governs 529 agreements say about the obligation to fund a series of requests? We don't know, because there was no evidence in the record. So that would be an interesting case, but that's not the case that we have in front of us.
Well, I'm not sure that that makes much difference. The obligation of good faith, just arises under contract law.
Sure. But if you're going to, I would note that the complaint itself doesn't say that the words bad faith don't appear in the complaint. The words bad faith don't appear in the argument in front of the court. The only allegation was that this was an arbitrary refusal, but that allegation wasn't accompanied by any evidence of any kind or any allegations that supported why they alleged it was arbitrary. So they are living with a complaint.
But an allegation that it was arbitrary is essentially an allegation that it was not the payment wasn't rejected in good faith. Arguably, but regardless of what was pleaded in the motion, and this was a motion to enforce, I'm a little concerned about the judge at the hearing. It's not expressed in the order, but basically saying, since it says sole control, my hands are tied, case closed. But not any suggestion that what you have argued here, that, well, maybe this is arbitrary, maybe not. I don't know, because we don't have the evidence. That's a different matter than what the judge said at the hearing.
The judge ruled on exactly what was presented to the court. They elected to go forward on a complaint that alleged one refusal to fund one request, and made the legal argument that she has the obligation to fund every request. The judge looked at that allegation, looked at the language of the agreement, and decided, I think quite correctly, that if she's given sole discretion, then that sole discretion means that she can make a decision not to fund a particular request. If they had wanted to present the case that you're talking about, Your Honor, suggesting that proving that it was arbitrary that she had acted in bad faith, they could have asked to amend so that they could have provided those allegations to the court. They didn't. Again, they could have asked the court to compel her to appear to deposition, saying that further evidence was necessary. They didn't do that. They elected to rise and fall on the very simple allegations of this complaint. That was their election. They chose not to amend. As far as we're concerned, we think that this issue is now settled because they presented it the way they wanted to present it, and they lost, and quite properly so. They lost. The only other thing I will say is that they say that the plan has to be used exclusively for the benefit of Alec Nichols. We absolutely agree with that, but the record contains no allegations or evidence that this 529 plan or the funds in the plan was used for any other purpose other than Alec Nichols. And the record doesn't contain any allegation that suggests that the former wife has any intention to use those funds other than for Alex's benefit. So again, they presented a very simple case to the court, a simple case based on a misinterpretation of the language and a misassumption that you have to fund every single request. That's wrong. The trial judge got it right. And for those reasons, we think that the trial court's ruling should be affirmed. He did nothing more than enforce the plain language of the agreement.
Thank you, Mr. Brannick. Mr. Blonsky.
Yes, Your Honor. And that was all actually pretty enlightening, because what we're dealing with is a record that shows that the allegation is, and what was submitted to the trial court was that the ex-wife was arbitrary. She received a request to fund what are unquestionably qualified educational expenses within the 529 plan definition. She did not do so, refused to communicate, refused to come to deposition, refused to come to hearing, and now we're being told, you haven't proven your case. Well, it was done in the way it was done to make this happen. And again, there are real world meanings to what appears to be a game that the ex-wife is playing, which is substantial tax penalties that arise from not using 529 funds and substantial tax losses by paying educational expenses outside of a 529 plan. The record shows she was asked to approve within her sole control what are qualified educational expenses. They shall be used under the language to benefit the grandchild. It's not, they shall not be used at all. They shall be used for that purpose. If the ex-wife's position was ever articulated from when this was filed till today, that, oh, there's a good faith, non-arbitrary reason, it's never been said. It's just, I can do whatever I want, and you haven't proven I'm arbitrary because I won't answer your discovery. That's not the way it works. It's certainly not the way it should work. And we presented as arbitrary. She hasn't said anything, even in her briefs, as to why it's not arbitrary. It's just, I refuse. I'm going to let the money sit here, and you have no recourse. And that's why we're here today, because we do have recourse. The grandchild's entitled to have her education paid for. It hasn't happened, at least since this motion was filed. What happened before, maybe that would be some justification for why things changed, but that never happened. These are qualified expenses. She wouldn't pay it. She wouldn't explain. That's all in the record. We've met our burden, and the trial court didn't read the rest of the sentence. Sole control does not mean you can do whatever you want. It means you have to act in good faith, not arbitrarily, not capriciously. The record here shows that's what happened. That's what we presented. The ex-wife said nothing to the contrary. That's a pretty clean record, I would say. So, for those reasons, we ask for reversal.
All right. Thank you both very much.
Thank you.
We will, in order to leave our virtual courtroom, you need to click this button on the screen called Leave, of all things, and you'll be off into the ether. All right. We are going to have a panel switch for the next case. So Judge Kazan turns off, Judge LeBrit turns on. There she is. Okay. Our next case is O'Brien versus Pride Enterprise.
Judge Northcutt, we just need the attorneys to turn on their cameras and their mics.
There he is.
Good morning.
Okay, Mr. Rose, you're up.
May it please the court, Neil Rose representing the appellants. I will reserve 5 minutes for rebuttal argument. Whenever a human endeavor creates a foreseeable risk of harming others, Florida law recognizes that a legal duty will arise. In such cases, the law places a duty on the defendant to lessen the risk or to take sufficient precautions to protect others from the potential harm of the
Let's
risk.
talk about the duty, Mr. Rose. What is the basis of this duty? Is it a judicial pronouncement, or is it arising from the facts of the case, or is it both? We know it's not a statute.
The basis of the duty specifically here is the woefully insufficient parking that the hotel had.
So
And
that is a fact.
It's
The facts of the case.
It's
That's where
the facts of the case recognized explicitly by this court in the Johnson versus Howard Marks production case.
So now you're saying it's both. It's judicial pronouncements and the general facts of the case. Good.
Correct.
I have another question for you that I'm going to ask you to shift gears on. You have argued, and it was debated extensively below, about the inference and the circumstantial evidence regarding the decedents going to the parking lot. Does this case turn on whether the decedents were in fact going to the parking lot, or if it was unknown? Now, without getting into the whole inference stacking argument, my question is, does the case turn on the fact that the decedents were or were not going to the parking lot?
I think that is an important fact, and I think there is a ton of evidence. Would you like me to discuss that evidence?
No.
before
What
dealing
I
with
want
the
to
duty?
know is, if the evidence was undisputed, let's just say that they were not going to the parking lot. If we had direct evidence that was undisputed that they were going to a restaurant or they were going to a store, does the hotel still have the duty that you're talking about?
I don't think so, because in that case, we couldn't argue that the hotel's woefully insufficient parking forced the decedents to cross a dangerous highway in order to get to the overflow lot.
So
If they were going,
In that situation, you're probably talking about causation. They still had,
there wouldn't be a proximate cause.
in the case law, as I understand it, they would have a duty to ensure the safety of their, or warn their guests about, the parking, to get across to the parking if they had to go there, but they don't have to, ensure their safety when they're going shopping, I don't think. And so, the question is, if they're going shopping, then the failure or not to guard their safety going to the parking would not be the cause of their death or injury.
I agree. And actually, if it's,
So you do believe that the case turns, as Judge LaBritte said, on whether or not they were heading for the parking lot?
yes, I
Whether
think
they were just out doing whatever else they might have been out doing?
to meet all the elements of duty and foreseeability and proximate cause, I think it's important that we show that they were heading to the parking lot, and there was sufficient evidence to prove that point.
Well, in the final judgment, the judge specifically said that there was no evidence that a jury could determine that they were in fact traveling to the parking lot. And I studied it pretty carefully. I'd like to know from you, what is your best argument for evidence supporting that they were in fact going to the parking lot? Understanding they were walking from west to east, but it didn't seem to me like anybody could say, well, they're going to get their truck or they're on their way to the parking lot.
No,
You're asking us to make an inference that that's where they were going, but what's your best argument to that effect?
sure. So first of all, if there's not direct evidence, there is at least an inference. You know that the guests were crossing Gulf Boulevard, and we say they were heading to the hotel's overflow lot at the time of the accident.
Okay, what supports that?
Eyewitness Mark Russa was on the eastern side of Gulf Boulevard.
All witness Russa could say is that they were walking towards him.
They were walking directly towards him, which is the opposite direction that he was walking from the hotel parking lot to the hotel. He even assumed they were hotel guests going to the lot because they were going in exactly that direction. There was not a roundabout movement. They were crossing Gulf Boulevard directly east, in the exact direction of the parking lot. They had their car keys with them. Their truck or car, whatever it was in the hotel parking lot with a parking pass a half a block east in the very direction that they were going. Rusa and the guests were on inverted or mirror paths. He was coming from the lot, walking right. He would have walked right into them. They were walking right in his direction, going from the hotel to the lot.
Does the record reflect what else was on the east side of the street there, like shops, restaurants?
Sure. I use the example. If the jury were to determine that the guests were walking to get a pizza for dinner, then maybe they weren't going to the lot. And maybe that's a reasonable inference, but it's certainly a reasonable inference that somebody is going exactly in the direction that they're headed. They're going due east.
It's frankly been a long time for me, but my understanding is inferences in a civil case, you have to have an inference that preponderates, right? So
no, I think you have to have a reasonable inference. We're not seeking to stack inferences here, as the hotel suggests.
But the inference that they were walking to the garage, to the parking lot, is no more reasonable than that they were going to get a pizza or going to a movie or whatever, just because they were having to be walking towards the parking lot.
But it doesn't have to be more reasonable. It has to be a reasonable inference. The jury is the one that makes that determination. They were walking in the exact direction where their car was, with their car keys in their hand, or at least in their fanny pack. We can't tell, but it would those.
Yeah, in the brief, I wanted to ask you about that. In the brief, you said they were walking with car keys in hand. Where did you get that from? How do you know that?
I got that from the evidence that showed when their personal belongings were picked up by the woman's daughter at the police department, it included the car keys.
So when you said in hand, you meant in possession, not literally.
In possession, yeah. Either the gentleman had the keys in his hand or pocket.
But those could be two very different things. I mean, if he's holding the key, getting ready to stick it in the ignition, that's different than if it's in the fanny pack because they're going out for pizza.
True, but if you take all these facts, the exact direction they were walking, the fact that Mark Rusa was on the inverted path, he literally thought they were guests going to the hotel lot because he was coming the exact inverted direction. The fact that they had car keys with them, the fact that their car was in that lot in the direction they were going, all those facts, when you take them together, a jury can make a reasonable inference that they were going to their car. That is a reasonable inference.
Let's talk about the duty itself for a second. The nature of the duty, you've got two duties as a landowner, generally speaking, in premises liability. One is the duty of care, and the other is the duty to warn of dangerous conditions. The duty at issue here is the duty to warn. Am I right?
I agree with that primarily.
Okay.
Yes.
I wouldn't necessarily agree with that, but
That's the primary duty. I'll agree with that.
And nobody can seriously contend that the hotel can control or maintain the public road. And there were already crosswalks at the end of each end of the block, right?
There was a crosswalk and a light, a block or two in either direction.
Which had a crosswalk.
I'm sorry?
It's a traffic controlled light, so it necessarily had a crosswalk. Okay. If the hotel had a sign saying, Gulf Boulevard is busy, crossing can be dangerous, use crosswalks, would that have discharged the duty to warn?
That might have discharged the duty to warn, but the fact that the dangerous condition was caused by the woefully insufficient parking.
Wasn't the dangerous condition caused by the fact that Gulf Boulevard is busy? And isn't that danger of a 5-lane roadway open and obvious?
Which, by the way, they'd stayed at this hotel twice before, so they're obviously familiar with Gulf Boulevard.
Sure, and that might be a matter of comparative negligence for the jury. But the hotel, by having the woefully insufficient parking, there are cases, including your case in Johnson versus Howard Marks, which says when you have woefully insufficient parking, that may very well lead to a duty.
Isn't Johnson distinguishable? Because there, no evidence was presented regarding the accident or the conditions of the premises, like whether there were crosswalks or traffic lights or lighting that would illuminate, I think it was Highway 41. Let me finish.
Sure.
And here we know that we do know the conditions. We know that there were crosswalks. We know that it was light outside because it was 6:45 in the middle of the summer. we know that these people were crossing in the middle, in between the two crosswalks. So they were jaywalking, as you said, a comparative negligence issue potentially. But we didn't know any of that for Johnson.
You didn't know any of that in Johnson because there was no evidence developed in that case. And what you said in Johnson was the woefully insufficient parking can lead to a duty, can be something for the jury to decide whether there is a duty if there was evidence to show the facts. We have now shown the facts.
I think the way the cases go is that created a zone of risk, which creates the duty. And so,
Yes, and
so there's a duty to warn or a duty to mitigate the danger. And so the reason I piped up and said I don't necessarily agree that this is strictly a duty to warn case is because I think a lot of hotels would have had a golf cart with a valet, taking people over to the parking.
That is
Boulevard was. I mean, there are ways that a hotel can mitigate the danger that a jury might find that they would have been reasonable, or that it was unreasonable for them not to. So I don't necessarily agree that this is strictly a duty to warn case. The zone of danger was created because the hotel had insufficient parking on its own side of. This is Gulf Boulevard, right? On its own side of Gulf Boulevard.
Yes, I agree with you. It just seems to me that
my problem, as I've indicated, is that I'm not sure that was the cause, because if they were not going to their car, then the failure to have adequate parking had nothing to do with this, and didn't. If they were going, as you say, to get a pizza, there you go.
I think I agree with you. But the fact is, there is enough evidence for a jury to make a single inference. When you take all those facts, they were going directly
as opposed to speculation. I mean, the parking lot was a parking. I gather the parking lot did not front on Gulf Boulevard, correct? It was
it was about a half a block down.
Right, so they could have gotten to the sidewalk on the east side and turned left or right.
Yes, that is possible. And a jury could make that inference, but there is enough evidence when you're going, if you're walking straight to a wall, a jury could make an inference that if you keep going in that direction, you're going to hit that wall. They were going straight in the opposite direction where Mark Russo was coming. He literally thought they were hotel guests coming from the hotel to the parking lot that he had just come from. So there is sufficient evidence for a jury to make an inference. If there's no direct evidence on that, there's certainly enough to make an inference. We're not seeking to stack inferences. It's one single inference. So not just Johnson versus Howard Marks, but a number of other courts under very similar circumstances stemming from insufficient parking have found this duty that is created. You have the Rapp case, First District in Rapp versus Tolbert Enterprises. Similarly found a summary judgment improper when a motel guest was injured crossing a highway to reach a motel from a remote parking area. Like our case, there were disputed issues of fact about the dangerousness of the road. Like our case, the motel directed the guests to park in the lot across a dangerous highway because the motel was—
Well, in that case, the court reversed for fact issues regarding the dangerousness of whether the highway was dangerous and whether the danger was open and obvious. And here, I'm not sure that either of those facts is in serious dispute.
Well, the defendants would agree because they tried to attack every single fact. They tried to claim that the hotel didn't direct these people to park in the lot where their car was actually in with a parking pass. They claim that the road wasn't dangerous when there's a ton of evidence that it was dangerous. They have all kinds of facts that they're trying to attack when there is factual support for all of these arguments. Let's also look at the Almirante case, Almirante versus Art Institute, 4th District Court. A student was forced to cross a busy highway to perform school functions and was struck by a speeding vehicle. Almirante said the school's decision to place its dormitory buildings on either side of a busy urban highway, requiring its students to cross one side of the highway on a daily basis, foreseeably created a greater zone of danger for its students from injuries while crossing. The Gunlock case, another 4th District case, remarkably similar factual circumstances. The decedent was struck and killed as he crossed a road to get from the hotel bar to his room across the highway. There was no pedestrian signal, crosswalk, bridge, or other safety device on the road to facilitate a safe crossing. Yet still, the 4th District said the hotel owed a duty of reasonable care for the safety of its invitees, whether that be providing warnings, use the crosswalk, will do something else, maybe have a golf cart, maybe walk the people across. Whatever a jury determines would be the reasonable thing to do to protect the decedents from the zone of danger that you created, the hotel created, by having woefully insufficient parking, knowing it, having literally an overflow parking lot.
Mr. Rose, you are
Forcing the guests-
into your rebuttal time, so proceed as you wish, but I just wanted to give you that heads up.
I'll save the remaining time for the rebuttal.
Good. Ms. Perona?
Good morning, Your Honor. May it please the court, Catherine Verona from Stoller Russell Keener Verona on behalf of the appellee Pride Enterprises, doing business as Sands of Treasure Island. We are here to ask the court to affirm the trial court's finding of final summary judgment in favor of my clients. We believe that the trial court correctly found that my clients did not create any foreseeable zone of risk by offering this offsite parking.
Let me
And
ask
that
you a
there-
question, Ms. Verona.
Yes.
What if we agree? What if we disagree that the trial judge, her conclusion that a jury could never find that these people were going to a restaurant? What if we accept your opponent's position on the inference? How does that change this analysis? If they were going to the restaurant, if they were going to the parking lot,
Right.
Or if a jury could find that they were going to the parking lot, what do we have here?
Yeah, Judge, while we obviously disagree with that, we don't believe that there any reasonable finding could be.
Let's assume
I think-
we don't agree.
Yeah, I still think, Your Honor, that there's still an issue concerning why they were going to the parking lot. So if you find that they were going to the parking lot, why does that create a dangerous condition? There was no evidence at the trial court level that we had insufficient parking. This case was
Well, of course you did. The evidence is undisputed that there are 13 rooms and 13 parking spaces on the sand side.
I think if you're issuing parking passes for a parking lot that's across Gulf Boulevard, you do not have adequate parking. The jury could easily find you did not have adequate parking.
Which is probably a problem for most beachfront hotel operators. But tell me, counsel, how is this case distinguishable from RAP? And you brought me to this because to be honest, I don't understand how you could seriously contend that the hotel did not instruct these people or require or tell them to park in this lot. They had the parking pass. It was in their car. It was probably the only place those cars could go. And so how is this case distinguishable from RAP, and why aren't we controlled here by Johnson?
Well, Judge, I think your point earlier on Johnson was correct, which is Johnson's summary judgment was reversed because it was just premature. They granted summary judgment without sufficient findings. They granted it solely based on request for admission.
So how do we reconcile Carter and Johnson, the
Right.
5th DCA's decision from Daytona?
Well, and I would say, Judge, that the issue has actually been before the court even more recently in October of 2022.
So you're talking about Martin,
I'm talking about Martin.
which is a
And-
completely different situation.
Right, but one that talked about Carter.
Yeah, it relies on Carter for
Right.
the general proposition, but I don't think we have anything like sidewalk tiles in front of a restaurant under an awning that
So
were
true.
city property.
Very true. So
I am
interestingly, Your Honor,
assuming,
Yeah.
I'm going to keep picking at you. I'm sorry.
it's okay.
I am assuming that you contend that the danger of crossing Gulf Boulevard between the crosswalks, that danger is open and obvious. Am I
And
right?
something that we cannot control.
Okay.
Right. So
Doesn't the question then become whether the hotel should anticipate that guests are likely to do this, and because it's the most direct route to get to their car, and that doing that could get them injured or killed? Isn't that something that the hotel could reasonably assess as a good possibility for their guests?
Your Honor, based on what the court found in Carter versus Capri, I don't think so. Kind of going back to this issue that the court talked about a landowner not being responsible just because their hotel sits on a public property and just because it sits on a public roadway, excuse me, and that we cannot be responsible for telling every single guest how to cross the street, how to use a crosswalk. We also cannot have every single hotel up along every single beachfront community in the state of Florida required to have a golf cart there running back and forth in between these parking lots.
Why
And I go
not?
back to, oh, sorry, Judge.
I mean, why not? I mean, like if I wanted to open a restaurant here in I live in Hyde Park. If I wanted to open a restaurant here, the city would require me to have adequate parking. And one of the reasons they would require me to do that is be safety. Now, why, when a hotel is getting permitted to be built on the waterfront, certainly the law could require that they furnish transportation offsite, correct?
Judge Northcutt, that's actually an interesting, I'm sorry, Judge.
Oh, no, I'm sorry.
The law does not require that. The statutory or code does not require that. But the question is, could a jury reasonably conclude that they should have done that to mitigate the danger that they created by not having adequate parking?
Well, then I think we'd probably, Judge, be talking about going back and talking about these hotels that have, like the Sands, been there for 40 plus years.
However long.
How would you mitigate?
I mean, maybe they were there before Gulf Boulevard became dangerous, but then it did, and they're still renting rooms.
Is it your position that a hotel proprietor who is providing offsite parking never has a duty to business invitees to ensure or ensure is too strong a word, but to provide for their safe passage to the offsite parking? Is it your position that can never be, and that's just never going to be a duty that should be?
Here's where I think it's probably distinguished, Judge LeBrit, is that what we're talking about here is we're talking about guests of the hotel that were injured off of our premises, right? So we're talking about, did our conduct as the hotel create this foreseeable zone of risk by having a parking lot on the other side? And what we will say is that we cannot control that roadway. Capri, or the Carter versus Capri case, talked about the fact that hotel had multiple different facilities on either side of A1A, which is much more busy than Gulf. And I would point to Christy Cooper's deposition, where she talked about the fact that, yes, sometimes Gulf Boulevard can be dangerous in the season, but there's also many times when Gulf Boulevard has 0 cars on it because no one is down at the beach.
So how do we, as a matter of law, thread that needle and say, well, sometimes there's an increased zone of risk and sometimes there's not? I mean, doesn't that then become a jury question if it can ever be an increased zone of risk?
Right. So I think it's a legal question based on duty and looking at the fact specific, this question was asked earlier, what is the duty based on? Well, it's based on this case on a case by case basis, right? So case by case basis, what did the defendant know about the dangerous or potentially dangerous condition and the foreseeable zone of risk that they were creating by having whatever amenity on the other side of the road, right? So in this case, the parking lot. Unlike in RAP, unlike in Gunlock, unlike in some of the other cases cited by the appellant, the hotel had no other incidents like this, right? No other situations of people being injured in this roadway, guests of the hotel. No reason to get a golf cart and take people across, because as Mr. Russa testified, people cross Gulf Boulevard on their own all the time. He'd done it many times. He never had an issue. He said he'd never do it again, of course. But that's what the hotel employees testified to as well. So Judge Northcutt, to your point, I think it's a case by case basis based on what kind of conduct did the defendant know was occurring in order to create.
Doesn't that then present a jury question?
I don't think so, because especially in this case, there was no question that there was no, I understand the allegation of insufficient parking is there. And I understand the court's position that, this number of spaces versus this number of rooms, that's insufficient. But we had no testimony from any individuals indicating that the decedents parked in that parking lot because they couldn't find a space? What if the decedents just decided to park over there because that's where they wanted to keep their vehicle and they didn't want to have to deal with getting out onto Gulf Boulevard in traffic? We have no evidence, of course, that they were walking over there. And so I don't believe it comes a question for the jury, Judge Northcutt. I think in this particular situation, it was pretty clear that no duty was created by my client's conduct in having that parking lot on the other side of Gulf Boulevard. You know, going.
Do you think it's
oh, sorry.
significant that the cause of these deaths was a drunk driver driving down the middle of the road? I mean, I'm not sure a crosswalk would have made much difference.
No, that's interesting, Judge Black, because I think, I don't remember if it was Marusa, the eyewitness, or if it was Deputy Bergstrom in his deposition testified that he didn't think being in a crosswalk was going to matter because of this erratic behavior. In fact, our hotel it sits at 118th Avenue. So just to the south, I think it's 117th, that light had turned red. There was no traffic coming that way. And there were minimal cars, according to Mr. Russo, coming from the northbound direction when this drunk driver, who was well over the legal limit and is now serving many years in prison, came from out of nowhere, was driving in the correct lane of traffic and then swerved into that median. So I think here it does play some factual role, especially when you're looking at the larger picture, which is, and has to be, what conduct of my client created a foreseeable zone of risk where they could have seen such a tragic accident occurring, when in 40 years of owning, well, maybe not owning it, but of this hotel sitting there, they'd never had anything similar. But really kind of coming back to, and I know we can agree to disagree maybe on some of it, but coming back to
in that 40-year history, do you know how many close calls there might have been? No.
That question was never asked.
Of course, close calls don't get reported and recorded. Correct.
Sure.
Yeah. But the judge ruled on two bases, according to the order, right? One, that the jury would not be able to determine that the plaintiffs or the decedents were going to that parking lot. And the other is that there was no foreseeable zone of risk that created by your client. Correct. And so when you argue that, well, you know, that none of that would have made any difference, that then is a causation, which I imagine it could be a tipsy coachman argument, but it wasn't the basis of the judge's ruling.
Correct, Your Honor. In fact, in her ruling, the trial court judge really seemed to focus on this idea of where were the decedents going at the time. And the fact of the matter is there just was no evidence. And again, a case litigated for 2 years, 13 depositions were taken, most of them.
That's a tough negative to prove, right? I mean, they're both dead. They weren't it doesn't seem that they were traveling with anybody else who would have had firsthand knowledge of what they were doing or where they were going. And your opponent makes a convincing argument that it's not an unreasonable inference for the jury to make that they were crossing the street to get to their car.
Well, you know, Judge Liebert, I understand where you're coming from, that it's a difficult kind of case to present as the appellant here, as the family to have this tragic incident occur. Obviously, you would love to place blame on someone. And unfortunately, in this situation, you know, the drunk driver is going to prison. I guess that's thankfully. You would like to place blame on the hotel. The problem is when you're talking about this foreseeable zone of risk, you have to go back to it being really a limited circumstance of when that foreseeable zone of risk is created, right? So this is not a situation, as you were talking about earlier, Judge Liebert, where you have a premises owner and his or her responsibility or its responsibility to people who come onto its premise. We are, in this case, trying to impose liability on my client for an incident out of its control in an area it did not control.
Is, you know, case law recognizes your obligation. It's not like this is a brand new theory that's being cooked up here. So,
very true.
And I'll tell you that going strictly by the judge's order, you know, I frankly have real problems saying there was no foreseeable zone of risk created by the parking situation. The question of whether the decedents were going to the parking lot, that's an iffier question, you know, but what was your client's burden in that regard? There was a time when I think the burden would have been for you to prove that they were not, you prove that they were not going there, correct? And now the burden is the plaintiff can't prove that they were. But at what stage of the proceeding do you do that? What if, you know, 3-4 months after this case is decided and then they decide that the plaintiff can't prove that the decedents were going to the parking lot. Somebody turns up, a neighbor that they called, would you check on our cat? And, oh, we're heading out to dinner. We're going to go get in our car and go to this steakhouse down the road. You know, suddenly there would have been evidence. So, you know, in terms of has it happened yet? But at what point can you conclude that the plaintiff cannot prove that?
So Judge Northcutt, if I'm understanding your question, it's kind of a timing issue.
It is.
And one thing I
know there's been a lot of discovery so far in this case, but does that mean that they are forever precluded from finding a witness?
Well, I would say that we litigated it for 2 years and we're literally at the eve of trial when the summary judgment is heard.
Had discovery
Yeah, I get it.
Had discovery closed?
It had, Your Honor. We were literally scheduled. In fact, the trial court judge had, we were having some difficulties finding time to have the summary judgment heard, and she was able to make time for this, given a pending trial date. I believe it was in November.
And this hearing was on like October 28th.
Yes, it was very close in time.
So just, and there hadn't been, was there anything in the way of a continuance to extend discovery, or was discovery well and truly closed?
To discovery at that point was well and truly closed. As you can see from the court record, plaintiff had filed all the depositions. You know, I can't speak for the appellant at this point, but I would assume that they felt comfortable with RUSA. You know, RUSA was the main focus of their argument, and RUSA, by the way,
Plaintiff didn't make the argument I just made.
Correct.
Right. They were going to rely on the inference of, you know, based on.
Right. Which actually kind of back to that point of the inference and where these people were going at the time. I just kind of wanted to go back to that issue of the inference, because there was some question about the inference and what is permissible in that regard. And during the hearing on the motion for summary judgment, we had referenced the O'Malley versus Ranger construction case. It's a 4th DCA case from 2014 that talks about, you know, that inference has to be established to the exclusion of all other reasonable inferences. Even in a non-stacking type situation, we need to have some certainty that it's not, as the court said before.
Actually, that I don't think that's illegal. I think the question is can they present evidence from which a jury could infer to the exclusion of something else? Reasonable. Right. So you don't have to. They don't have to completely disprove any other scenario, right? They have to give enough for the jury to make that inference.
Correct. And in this situation, what the trial court found was that there were so many other possibilities, so many other reasonable inferences of where these individuals could be going. Again, let's remember, you know, this parking lot that we're talking about does not sit on Gulf Boulevard. So Mark Russo was not standing in the parking lot itself. He is standing on the corner of Gulf Boulevard with the parking lot about half a block to a block behind him. So appellants at the summary judgment level relied on Russo's testimony. Again, did not take Russo's deposition themselves, relied on Russo's deposition that was taken in the criminal court matter. And Russo said, I assumed that they were coming from the hotel and going to the parking lot because of the path that they were taking. But there are tons of other reasonable inferences about where they could be going. They could have crossed the street and taken a left.
Gotten across Gulf Boulevard, right? They were in the center lane. When
they were in the median, yes, yes. I mean, and there's a Circle K kind of catty corner to this. There's other restaurants and bars up and down. They could have been maybe even going just to golf to look at the golf. They could have been going for a walk. There's tons of places they could be going. And the court has already pointed out one thing that we wanted to note earlier, which is, you know, numerous times throughout the initial brief and the answer was discussed that keys in hand. There is no evidence that the keys were in hand. There is solely evidence that the keys were picked up. keys could have been with them for any reason, just not ever leaving home without your keys. And so, you know, with all of the testimony that was taken, which was numerous employees, both personal representatives, the deputy, you know, Deputy Bergstrom, which we haven't spoken about really. He is from the Pinellas County Sheriff's Office. They did an exhaustive investigation, given the horrific and tragic nature of this accident. They were not able to make any conclusion that these individuals were walking anywhere other than west to east. In fact, there is a part of Deputy Bergstrom's testimony, I believe it's in the record at page 417, where they said they had to go comb nearby hotels to figure out where these people were even staying. They knew they must have been staying somewhere. But after the fact, you know, they had to go do that. So Deputy Bergstrom himself did not even make that determination that these individuals had left my client's hotel and were going to this parking lot. There simply was just no evidence. We believe that the trial court was correct in her finding that no jury could determine that that's where they were going. Even looking at an inference, there's many other inferences about where they could be going at the time. And going back to something that Judge Black had said, which is, you know, again, it's important to keep in mind that even if we say there's insufficient parking, even if we say that Gulf Boulevard is a dangerous place, these two decedents had been there before. They had, in fact, just been there in February 2018. They chose not to use a crosswalk. We had two available crosswalks on either side, one right at 119th and one at 117th. They chose not to use it. They could certainly do that. People could use crosswalks instead of us shuttling people dangerously back and forth.
Yeah, but I think you're making a jury argument there, Ms. Verona. Not that we haven't heard those before.
Thank you, Judge. Jury argument as it is. It was in the record.
Yeah.
And it is something to be noted factually about the case. But Your Honors, at the end of the day, I think that our position in the case remains what we kind of started off with today, hearing from Mr. Rose, which is, you know, in this case, there was no duty created. There was no foreseeable zone of risk. We cannot hold hotels in the state of Florida responsible for everyone who crosses a public highway that they are not responsible for. And in this particular case, there simply was no evidence that these two decedents were going across the street to get to the parking lot. So we would ask that the court affirm the lower court's finding of summary judgment in favor of Pride Enterprises. I appreciate your time.
Thank you very much. Okay, Mr. Rose.
Thank you. If you heard counsel carefully, she said that there were other reasonable inferences as to where the decedents were going. That's right. There were other reasonable inferences besides our reasonable inference. So a jury, not the judge, gets to determine that. And the Supreme Court said in Nielsen versus Sarasota, which we cited, in a civil case, a fact may be established by circumstantial evidence as effectively and as conclusively as it may be proved by direct positive evidence. And the only limitation is, if you're going to stack inferences, only then must you prove the first inference to the exclusion of all reasonable inferences. Counsel was mistaken saying we have to prove that inference to the exclusion of other reasonable inferences. No, we don't. We just have to show that there's one reasonable inference, and we did. This result below cannot stand in light of this court's decision in Johnson. The hotel increased the zone of risk to the guests in the exact way that Johnson said a zone of risk could be increased, by having woefully insufficient parking. It's just that there wasn't the level of proof, and Johnson reversed the summary judgment to allow the proof on that issue. We have the proof that there was woefully insufficient parking that increased the zone of risk. The hotel manager knew that there were accidents in front of the hotel. The police said this was a dangerous incident, a dangerous road. The news wanted to do a report with the decedent's daughter because this was such a terribly dangerous road. So to
One
argue
of the positions that you take, Mr. Rose, is that this knowledge was unique to the hotel, and that's why they had to be warned. But now you're telling us that everybody knew how dangerous it was, and the decedents had stayed in the hotel at least a couple of times previously, so they knew too.
that would be a matter of comparative negligence, and that's an issue that the jury is
Well,
going to
that
have to
also
decide,
goes
not
to
the
open
judge.
and obvious. Would you agree?
Then you would have the situations in the other four cases I cited where you have people crossing a dark road Of course,
But this
people know
wasn't a
that-
dark road.
No. So the zone was increased by the conduct in having woefully insufficient parking. And in that case, the defendant has to either warn or lessen the risk. They did nothing to do that. If the decedents knew it was a
The
dangerous
only
road,
way they
that
have
is
to, wait, the only way they have to warn though is if it's something that wouldn't, that the plaintiffs needed to know, that the defendant knew and the plaintiffs didn't, that was unique to the
there's no
defendant.
evidence that the plaintiffs knew. You're hypothesizing. Maybe they did, maybe a jury can determine they did, but that is an issue for the jury to determine.
That's why I think this is a failure to mitigate case.
It could be either, it's going to be the jury that
Judge LeBret
determines.
and I don't always see eye to eye on things, but we often come to the same result.
Yeah, the jury is going to have to determine what measures the defendant should have taken, because the right conclusion under Johnson and the other cases cited is that this hotel increased the zone of risk. They didn't do anything to warn or mitigate the danger. And it's going to be up to a jury to determine it. Counsel even admitted that our inference was reasonable because she was talking about other reasonable inferences. So our inference is absolutely reasonable. They were going in that exact direction. Any jury could easily determine, of course, they were going to their car. That's exactly the direction they were going, the inverted path of Mark Russa. So both of the rulings by the trial court were wrong on the inference. And we have the right to prove that by circumstantial evidence, and jury has the right to make a decision about where they were going. And secondly, the error on the duty is just a legal error. It is not consistent with Johnson. The defendant's reliance on Capri, it can't be sustained. That case did not involve this sort of woefully insufficient parking. And in any case, it's not this court's decision. So if you follow Johnson, this result cannot stand. Thank you.
Thank you, Mr. Rose. Thank you, Ms. Verona. Well argued case. In order to leave our virtual courtroom, you need to click the leave button, which is on your Zoom screen. You'll disappear. All right. And I see Judge LeBret is leaving us, and now we'll have Judge Kazam come back for the next case, which is Geico versus Shazam Auto Glass. Multiple times. Huh? Okay, Mr. Trowell, you're up.
May it please the court. My name is Lindsay Trowell, and I represent the appellant Government Employees Insurance Company in these consolidated appeals. I'd like to reserve 5 minutes for rebuttal.
Sure.
These appeals arise out of a single bench trial of 4 cases consolidated for trial. The cases were simple single count breach of contract cases asserted by Shazam against Geico.
And
These-
Mr. Trowell, can I just kind of cut to the chase?
Sure.
You've indicated that this was as a result of a trial and evidentiary hearing. Help me out in the sense that didn't the trial court make basically a credibility argument based on the evidence presented and did not basically agree with your expert witness, but rather accepted based on the credibility and the testimony, your opponent's expert witness? And what I'm having difficulty with is reading through the brief. Are you asking us to reweigh the evidence, to reweigh the credibility, to basically discount the trial court's conclusion in this matter? That's where I'm having a problem with. And if you could address that for me.
Yes, Your Honor. No, we are not, as against what the appellee would have the court believe, asking for a reweigh of the evidence. What has occurred here is that these credibility determinations, Your Honor, it's clear from the final judgment that the court has misapplied the evidence to the standards set forth by the 13th Judicial Circuit trilogy of cases in Matthew Dick 1, Matthew Dick 2, and the Gilbo-Robbins decision, Your Honor. What's occurred here is the judge has viewed and misinterpreted that standard set forth, and in fact points to it in their own footnote in paragraph 2, where the court itself says in footnote 2 of their opinion, says The court notes the difficulty this trio of appellate cases, which establishes the test and respective burdens with regard to the prevailing competitive price, has caused. This has caused great confusions not only with the parties, but also on the trial court in determining precisely, and this is key, what evidence is sufficient in establishing the prevailing competitive price. In particular, the reference to non-insurance transactions and what constitutes the same. It's clear that the court's confused by the standard that's set out by these trilogy of cases. And if you look to the court's order, when the court's trying to determine, did GEICO pay the prevailing competitive price? How can the prevailing competitive price be proven or identified? To me, that's answered in that footnote.
But the only evidence that was put on about prevailing competitive price had to do with contracts that GEICO was party to.
Your Honor, there's no evidence of that in the record. There is no contract that was executed by GEICO or any other party that was presented in evidence.
I mean,
There was
correct me if I'm wrong, but my reading was that during trial, no evidence was put in about the prevailing competitive price.
Yes, Your Honor.
As compared to what Shazam was charging.
No, Your Honor. I think that is an inaccurate recitation of the evidence that the court viewed.
I guess more specifically, evidence was put in, but only with respect to contracts that GEICO was party to or had an agreement with the glass company.
Your Honor, there is no evidence of an agreement in this record. There's what's referred to as the GEICO glass pricing letter, Your Honor, which is simply a notification that's addressed to no one that GEICO sent out. The testimony is that GEICO sent this letter out to every shop in the state telling them this is our parameters. It's nothing more than a notification. It's countersigned by no one. It's executed by no one. It can't be an agreement. This is the confusion.
Now, regardless of whether it's an agreement, isn't it inherently inconsistent with the notion of competitive price?
Your Honor, I think the 13th Judicial Circuit.
Hey, this is what we're going to pay, not, hey, we're going to pay the prevailing competitive price.
Your Honor, I would state that's how our market works in every instance. You have
that's not what the insurance contract says.
The insurance contract says they're going to pay a prevailing competitive price, which is the price.
That is people to shops that are competent and convenient.
Right, but it's also defined in the policy as the price that GEICO can secure. Your Honor, take a transaction with General Motors. If someone wanted to know how much a certain vehicle would cost, you'd go learn about what the transacted costs were for a given number of vehicles in a given area from relevant different dealerships. You wouldn't ask them, how did you arrive at the final sell price, or how did you determine the list price? No, you'd want to know, what are the competitive players in the market transacting at? And it's exactly what GEICO introduced. And it's the trial court's misunderstanding that any transaction involving GEICO with a ready, willing, and able non-affiliate shop that bills GEICO at GEICO's parameters, that transaction can't be a competitive transaction. And that's a complete misapplication of the standards set forth in Matthew Dick 1 and the other two cases, Your Honor.
But if I may, Mr. Trowell, isn't that the prerogative of the trial court? Your expert didn't really come out and say specifically that for those places, he basically was kind of very narrow in his conclusion. And comparing that with Shazam's expert that went through and explained exactly why this ought to be what is the competitive price versus the non-competitive price. It's a battle of experts. It's not a matter of that the court discounting, very unrebutted testimony. There is a dispute as to what would be the prevailing competitive price. And the court basically came to a conclusion, circling back to my first initial question to you, as a credibility, the trier of fact, he chose to reject your expert and accepting Shazam's expert.
Yeah, Your Honor, but if we ignore the fact that she's misapplying the standard, so if you set off a standard and you've excluded a certain type of evidence, and that's the evidence that one party relies on, certainly the court's going to come to a credibility understanding. The problem is is her understanding of the standard is the error we're seeking to reverse here. Matthew Dick 1
I guess, Mr. Trump, I'm trying to understand, because as I read the transcript, Geico's taking the position, these are the folks that we deal with, and we're telling these folks, this is what we're going to pay. Just by virtue of them saying, this is what we're going to pay, or this is the parameters going to pay, that does not make it competitive. And those companies choose to do that. That really doesn't come to the conclusion that is, according to the contract, what is a competitive price. And given that, with the testimony presented at trial from another expert that brought this to light to the court, that this is what Geico has done, and basically bring in evidence as to what would be the competitive market price, that's where I think I have an issue and a concern with your position in this case, that you're not asking us to reweigh the trial court's determination as to the credibility of the experts.
Yeah, Your Honor, I don't believe we're asking you to do that, because I think we think the error is the application of the standard, and how the judge views the evidence within that standard matters. It creates error. And to answer your question, simply sending out a notification of what we pay doesn't mean it's not a competitive price. It's no different than how any of us transact in any market. The price is known, and whether or not you're going to have a meeting of the minds and you're willing to transact at that price creates a market transaction. Okay, there is a published price, but that price doesn't become a market transaction until someone actually agrees to the price and transacts at that price. And what we have to look at here is the trial court's interpretation of prevailing competitive price under Matthew Dick 1 and Matthew Dick 2. They entered a pre-trial motion in limine that says, Geico, you can't rely on any transaction where Safelite was performing the windshield, because you have an actual agreement there. You can't rely on any affiliate transaction. Affiliate shops are non-Safelite shops but are a member of Safelite's network. You can't rely on that because they're a part of Safelite's network, despite the only testimony about affiliate shops being that they are free to accept and reject the job based on the pricing. So they are a ready, willing, and able buyer. But even against those odds, Geico only presented transactions with non-affiliate shops, not non-affiliate shops that Geico only transacts with. These are non-affiliate shops that have no relationship, no contract. There's no evidence in the record of a contract. And these are shops that Geico understands that there's a loss. They understand that their insured has identified this shop. This is the way one of these transactions occur. Geico transmits a work order, just as they did here in Shazam, and Shazam admitted to. That work order says, here's what we're going to pay. And the shop at that point can choose to accept the job and replace the windshield. And that's the evidence we presented. And what Judge Valkenburg said in paragraph 26 of her order is Geico presented only evidence that involved transactions in which Geico was involved in. What other evidence is there in the face of Matthew Dick 2, which states that any other transactions related to other insurance companies are irrelevant? That's what Matthew Dick 2 says, because the policy language isn't the same. So the only transactions that can be irrelevant are transactions that have been adjusted under Geico's policy. And here you have non-affiliate shops. But the way the court is applying the evidence in paragraph 26 through 30 is that any transaction Geico's involved in is an insurance transaction and irrelevant. And any transaction Geico's involved in that they show that they are securing at their parameters can't be relevant, because the judge is saying they must be pursuant to an agreement.
Well, let me ask you, Mr. Trowell. I mean, the evidence in this case showed that Shazam set its price in part, and largely, I think, based on the NAG's schedule. Couldn't the court, and he said, does it based on the NAG schedule, based on consulting other shops and to come up with a price that's reasonable and competitive? Did you offer any evidence that it wasn't? I mean, why couldn't the court accept that testimony and say, yep, that's the case, and that fits the definition under the statute? And just because you're under the policy, and because you seem to be unwilling to pay that doesn't alter your obligation under the policy.
Well, neither party offered any evidence with respect to what NAGS is or isn't other than a published list price. In fact, when Mr. Martineau was asked in the record about the preface of the NAGS publication that indicates it's not indicated to be a retail price, he wasn't aware of it. So that was the only real testimony about what NAGS is or isn't. Both parties have what I would call parameters. Shazam applies. Let's look at the NAGS list price. We charge 100% of that.
You know, my point is, he says NAGS, consulting other shops, informal surveys with other shops, et cetera. Why wasn't that sufficient to show that that was a competitive prevailing price, and therefore they win?
Well, Your Honor, first of all, I think that the burden was thrust on GEICO to prove the prevailing competitive price. I don't think the court is indicating that Shazam has proven the prevailing competitive price. I think they're saying GEICO didn't prove it.
Paragraph 17 of the order, the court points out that Dr. Mellish opined that Shazam's invoice pricing was consistent with the invoice price submitted by other non-affiliate shops in the Tampa Bay market. In other words, finds that Shazam was appropriately setting their prices, and the court heard that testimony from expert Mellish and accepted it, and that's the basis of the ruling.
Well, Your Honor, that goes on, Judge Black, that goes on to paragraph 24, where the court holds that Shazam's pricing was usual and customary, fair and reasonable, which is exactly the grounds for which Matthew Dick 1 was reversed, because the underlying trial court held that the pricing by the shop was usual and customary and reasonable. That's not the standard that Matthew Dick 1 set forth, and it's certainly not the language of the policy. It's prevailing competitive price, and we urge that the policy says it's what we can secure, which makes sense. That's what is a market price. What is being transacted at? Where are the parties having a meeting of the mind? So from that perspective, we continue to think that the court's application of the evidence is misplaced, and in essence in paragraph 26, throwing out any non-network transaction where GEICO was operating at its parameters, simply because GEICO was involved, and simply because these non-network who have no agreement, there's no agreement in the record, were willingly billing GEICO pursuant to these parameters and accepting the job and performing the work. Now, moving on to GEICO's affirmative defense as to waiver, Your Honor, we believe GEICO presented sufficient evidence of waiver in this case. The court has judged the standard, misapplied the standard. The judge is indicating that to prove waiver, one must show that there was, in essence, a tacit actual agreement. That flies in the face of Florida's standard jury instruction, which clearly states a waiver may be oral or written or may arise from the conduct, which shows that the claimant gave up the right. Shazam's corporate rep testified that not only did he receive the GEICO work orders, this is at the record at 5168, not only did he receive the work orders in 3 of the cases, not all 4, he then states, but you knew what GEICO, as you said, wanted to pay on these claims, correct? Yes. They communicated to you what they wanted to pay, correct? In the 3 cases, yes. So prior to him deciding to perform the replacement, he knew exactly what GEICO was going to pay and chose to perform the service.
Mr. Trowell, you are at your rebuttal times. Proceed as you wish.
Okay, about 1 more minute, Your Honor.
Sure.
And citing to, in our brief, A&E Auto Body Inc. versus 21st Century, as courts have explained, and this was in a quantum merit claim, Your Honor, as courts have explained, in dismissing the claims against GEICO and other insurers, where the repair shop proceeded to make repairs after being advised by the insurer how much it would pay, with foreknowledge of the amounts defendants were willing to pay, the plaintiff could not have any reasonable expectation of receiving more. That's what happened here. We presented the work orders were admitted into evidence. Mr. Martineau admitted receiving them. He admitted understanding what GEICO was willing to pay prior to performing the service. We believe he's waived any right as an affirmative defense to collect additional monies, and I'll reserve the rest for rebuttal, Your Honor.
Okay, you have right at 4 minutes.
Thank you, Your Honor.
All right, Mr. Caldevilla.
May it please the court, Your Honor, I'm Dave Caldevilla and I represent Shazam Auto Glass in this appeal. This is the third time that Geico has appealed from a closely similar final judgment issued by Judge Valkenburg, sitting as a trier of fact in a non-jury trial, where she found that Geico failed to present credible evidence. In August 2022, in Geico versus Glasgow, which is case number 2D21-359, a panel comprised of Judge Northcutt, Judge Rothstein Yorkham, and Judge Stargill issued a PCA affirming a practically identical final judgment issued by Judge Valkenburg. More recently, on December 28th, in Geico versus Superior, as a signee of Fontaine, that's case number 21-2593, a panel comprised of Judge Northcutt, Judge Black, and Judge LaRose issued another PCA affirming another practically identical final judgment issued by Judge Valkenburg. And if you go back and look at Geico's initial brief in the Superior appeal and compare it with Geico's initial brief in this appeal, you'll see that they're basically carbon copies of each other. So as in the Glasgow appeal and the Superior appeal, Geico is once again inviting this court to ignore Geico's burden of proof, reweigh the evidence presented at a two-day trial, and disregard fundamental principles governing the standard of review, preservation of error, and the presumption of correctness. Since the dates of the Glasgow appeal and the Superior appeal, the controlling law has not changed, and neither have Geico's erroneous arguments. So to quote Yogi Berra, this appeal is like deja vu all over again. Under the standard of review, the trial court's finding of fact in a non-jury trial are clothed in a presumption of correctness. They can only be reversed when they're unsupported by any competent substantial evidence, and the appellate court is not allowed to reweigh the evidence or engage in de novo fact-finding. Geico wants to turn that standard upside down by portraying the evidence in the light most favorable to itself, instead of the light most favorable to the trial court's determination. And we just heard that from right off the bat, Mr. Trowell's argument about waiver. Geico presented sufficient evidence of waiver. That was his argument. That's not the standard. The question is whether the trial court's rejection of Geico's evidence is supported by the record, and it certainly is. And I'll get to the waiver argument, but counsel argued that this burden of proof was thrust upon Geico. That's not so. In this case, it's undisputed that all four of the windshields is a covered loss. Geico admitted that. And so therefore, the primary issue at trial and on this appeal is whether Geico met its burden of proving those two affirmative defenses. The first being that Geico's payment amounts complied with the prevailing competitive price provision in the insurance policy. The second is that Shazam waived its right to recover that price. So both during and at trial, Geico conceded that Geico had the burden of proof on both of those affirmative defenses. It wasn't thrust upon them. They said right at trial in their opening argument at page 5097 of the record, Geico has the burden, Your Honor, the burden as to its affirmative defenses, both the prevailing competitive price and waiver, Your Honor. They admitted they had the waiver. That's the law in Florida. The insurance company has the burden to prove these limitations, and a waiver is clearly an affirmative defense as well. Geico presented, their problem is they presented no credible evidence to support the limitation of liability defense. Now, counsel says, well, look at footnote 2 of Judge Valkenburg's final judgment. By the way, that same exact footnote was found is in the Glasgow final judgment and in the Superior final judgment. Doesn't matter that the judge was pointing out that, hey, there's this non-insurance transaction element or statement that the Dick case has thrown into the mix here. What matters is if you go to paragraph 29 of the final judgment, Geico's evidence has no credibility. She says on paragraph 29, neither of Geico's witnesses created or generated the claims history spreadsheet. None of the data listed on the claims history spreadsheet was adequately verified as being accurate or corroborated with any of the underlying billing and payment records summarized therein. Geico also failed to present credible evidence that any of the windshield shops listed on the spreadsheet were competent, conveniently located, or in a position to perform any of the insured customers' windshield replacement jobs at the time, date, and place requested by these four insured customers. Further, there is no information regarding whether the amounts paid were ever contested by the receiving company or whether additional payments were subsequently issued by Geico. Let me explain that. This claims history spreadsheet identifies, and there's 69 transactions per page, and it's over 100, it's about 150-page document. And each line of that spreadsheet is a summary of information plucked from other documents without presenting any proof of the underlying document. It's an irrelevant and inadmissible piece of evidence from many levels, but the trial judge went ahead and let it in. This is a non-jury trial. She let it in, but she recognized this evidence is worthless. That Geico admits that when they put down the price that they pay on that spreadsheet, assuming it's accurately transcribed, if they say they paid $500 for a windshield, if Geico later determines that they underpaid that claim and they issue an additional payment to the windshield shop, it is not reflected on the claims history spreadsheet. So they do not update it to put the correct price that they actually paid. And we don't know how many transactions on the spreadsheet had that situation going on. So it is inaccurate and unreliable at the outset, not to mention the fact that Geico refuses, I'm talking refuses to present any of the underlying records that they used to create that monolithic piece of hearsay. Another giant problem that they had, and this had nothing to do whether it's non-insurance transactions or not, it just has to do with this claims history spreadsheet cannot be relied upon. It's inadmissible. The other problem was their own expert. In paragraph 30 of the final judgment, the judge says, Geico's expert witness, Dr. McClave, did not credibly establish that his analysis was based on adequate, relevant, and accurate data or an appropriate and reliable methodology. It doesn't matter whether it was insurance transactions or non-insurance transactions. He didn't verify the accuracy of anything he relied upon. So what does this boil down to? Geico says, oh, well, they thrust this impossible burden on us. No, Geico, you know how to prove this case. You filed 100 and something page motion at page 539 of the record called Geico's motion for continuance to determine infeasibility of a 2-day trial in light of defendant's material witnesses. So this was a motion where Geico said, Your Honor, we have 169 witnesses who are corporate representatives from 169 windshield shops, and they're going to testify because we have the burden to prove that Geico could have secured a price from a competent and conveniently located windshield shop, the same prices that we paid for these 4 windshields to Shazam. We got to call 169 witnesses, or we're able to call 169 witnesses to prove that these shops would have accepted the lowball prices that we paid to Shazam. This was a big bluff so that they could get a continuance. I'm sorry, did somebody shout? That was a bluff so that they could get a continuance. But if you read that motion, Geico understands clearly what its burden is. And that is to put on some windshield shops, put on a number of windshield shops who say, yes, we're competent. We've changed windshields on 2011 Kia Souls and Mercedes C230s. We've been changing them for years.
And
you know
Mr.
what?
Caldevilla, so isn't that the bottom line? This was just a trial on a battle of experts, that the court simply rejected one and accepted another, and not
Yes, Your
really
Honor.
as to the exact competency of the testimony itself. I mean, you know, the trier of fact could weigh the credibility, could agree or disagree, disregard, approve, disapprove any factual determination before them. Isn't this, in a way, Geico's asking us to reweigh the evidence of the trial court entered below?
Absolutely. That's exactly what they're doing. They're trying to portray it as, oh, the judge used the wrong legal standard, but the only thing they can point to is this footnote 2, where the judge says, well, I'm not sure what Dick means as a non-insurance transaction or not, but it doesn't really matter because it just said all their evidence lacks credibility. It doesn't hinge on this non-insurance transaction issue that the Dick decision talks about. And Geico never once complained about the Dick 1 case. In fact, they told the judge that she's required to comply with the Dick case. And now they want you to reverse it, basically. They're asking through the back door, please reverse the Dick case. In a few weeks, Judge Northcutt, you're going to hear the Dick appeal. And Geico says in that case, well, the Dick standard is correct. In this case, they're saying, wow, it's confusing and you shouldn't follow it.
Yeah, I ever since our jurisdiction changed, I'm seeing a lot of you guys.
Becoming quite an expert, you all become quite experts on small claims and windshields, and so am I. With respect to the waiver argument that Mr. Trout touched upon, let me point out that Geico doesn't want to mention that their own policy says at page 5734 of the record, their insurance policy says the terms and provisions of this policy cannot be waived or changed except by endorsement issued to form a part of this policy. All right, so they're saying, so once the policy itself says you can't waive anything in this policy, but they're saying that my client, of course, did waive it. How? Because we sent you a work order telling you what we were going to pay. Well, my client is standing in the shoes of the insured. The insured negotiated or got an insurance policy from Geico where Geico said the amount that they were going to pay. They negotiated with my insured and said, we're going to pay the competent, the prevailing competitive price, which is the price we can secure from a competent and conveniently located shop. So then Geico sends out this work order, and this letter says, well, we're only going to pay half of the fair market value. So like it or not, that's all you're getting. Well, the windshield shops that's not part of the policy. It's nothing. It's just a Geico being a bully saying we're just going to pay half. So live with that and don't pay any attention to our policy because we're not paying any attention to the policy. That's just not the way it works. But Shazam didn't waive anything. There's no evidence of it. Certainly, the judge's findings on the lack of waiver in this case are clearly supported by competent substantial evidence in the record. So just like Judge Kuzam says, this is just an attempt to reweigh the evidence. Although Mr. Trow hasn't mentioned standing, he raises in his brief that Superior has standing, and that there was, according to him, the assignment of benefits that was signed by their insured is inadmissible. This is clearly a business record. The predicate for demonstrating the hearsay exception for business records is clearly in the record at pages 5126 through 5138. Once that burden is met, the non-moving party has a burden to prove that there's a lack of trustworthiness. There's no evidence of that. Instead, Geico relied on that assignment of benefits and paid what it contends was the full amount that it owes. They say we paid every penny. How can you say that the assignment of benefits was not trustworthy when you relied on it? In fact, the ITT real estate equities case by the 4th DCA says exactly that. When there's a written instrument offered against the party, it's presumed to be genuine by proof that the party against who the document is offered has acted on it as being genuine. That's exactly what happened in this case. I don't know that I really have much more to say than what's already presented in my brief. I think now we're at the third identical appeal by Geico. They've beaten this dead horse to death, and I request your honors to affirm. Thank you.
Thank you, Mr. Caldavia. Okay, Mr. Trowey, you have 4 minutes for rebuttal.
Thank you, Your Honor. I will address the burden of proof. The trial court erred in requiring Geico to prove that it did not breach the policy of insurance. And as discussed, obliterated Geico's ability to meet such a burden by the misapplication of the evidence, not a weighing of the evidence, a misunderstanding of the standard, and therefore a misapplication of the evidence. Shazam's statement of claim asserts a breach of contract claim. It states by failing to make a payment as described in the insurance policy. The prevailing competitive price, the limit of liability in the policy, is not an affirmative defense. The cases the 13th Judicial Circuit rely on and Shazam relies on in Matthew Dick 2 and Gilbo Robbins, State Farm v. Curran, are all distinguishable. In State Farm v. Curran, 135 Southern 3rd, 1071, Florida Supreme Court, the suit arose out of a denial of coverage, and such denial was not premised on a coverage exclusion or limitation, but a denial of coverage in its entirety. We all know that a denial of coverage is clearly the burden of the insurer to support that denial of coverage. So it didn't arise out of an exclusion or a limit of liability. In St. Paul Mercury v. Coucher, 837 Southern 2nd, 483, is similarly misplaced. In that case, the insurer's position was that coverage was available provided the amount of liability exceeded all other available liability coverage. In other words, coverage is excluded altogether under the other insurance clause. Again, an exclusion is clearly, the burden is clearly on the insurers. That's the standard of law. Here, the prevailing competitive price is not an affirmative defense. Remember, an affirmative defense is one that admits the underlying cause of action, the breach of contract. GEICO is not admitting that it breached by failing to pay the appropriate amount and therefore seeking to be excused from that breach. That would be waiver. Prevailing competitive price, the burden should be on plaintiff to prove that GEICO didn't pay pursuant to the policy as alleged in the claim. The most relevant case, which is cited by us in our brief, is U.S. Liability v. Bove, 347 Southern 2nd, 678. That's a 3rd DCA decision, where there's no dispute between the parties whether a particular loss is covered. The plaintiff has the burden of proof. GEICO is not disputing coverage. On the contrary, GEICO paid for them, and it is plaintiff that is disputing whether GEICO paid appropriately under the policy. Therefore, the prevailing competitive price cannot be an affirmative defense. I go back to the errors, Your Honor. We talked, Mr. Caldavia talked about the claims history. This isn't a weighing. Clearly, a piece of evidence would lack credibility if you hold that no transaction that GEICO's involved in that was conducted at GEICO's parameters are relevant. Well, then certainly the claims history isn't credible because it presents transactions GEICO's involved in under its policy with non-affiliates that transacted at those parameters, i.e. pursuant to the policy, it's showing actual transaction where GEICO secured the price, Your Honor. With respect to these supplemental payments, that was addressed in Matthew Dick 2, where the court said, moreover, that GEICO has previously paid some invoices in full is misleading where there are signs the invoices were disputed, i.e. subject to litigation. Mr. Martineau testified as much, that the only time in which his invoices were paid in full is when he brought litigation and they were settled in the context of litigation. Your Honor, the waiver claim is no different. We seem to be hung up on this idea that GEICO is sending the notice letter of the prices and the work order, Your Honor. This is no different if you got in an accident in your car, an adjuster showed up, they present an estimate of what it's going to take. You either accept that total estimate or you don't. That is what the work order is. That's what Mr. Martineau said he received. And that is exactly, and he chose to do the job and now he seeks payment of more. That affirmative defense should be reversed. Judgment should be reversed and judgment should be entered in favor of GEICO. Your Honors, thank you for your time.
Thank you both very much.
Thank you.
In order to leave our virtual courtroom, you click the leave button and you'll be gone.
Thank you, Your Honors.
Take care. Okay, the court will be in recess for 10 minutes. Okay, we got the whole team here. Next, we'll take up Martin versus Martin. Like your dog, Mr. Townsend.
Good morning.
Good
Oh,
morning,
my-
Your Honors.
Morning.
Okay, Ms. Lena, you're up.
May it please the court, Angela Liner on behalf of the appellant Kimberly Martin, now known as Kimberly Jack, the former wife in the underlying proceeding. I'd like to reserve 5 minutes for rebuttal. We're here on the trial court's amendment or modification of a final judgment nearly 3 years after that final judgment was entered, without a supplemental pleading, without a proper motion for rehearing or appeal of the original final judgment. Basically, equitable distribution was modified.
And Ms. Liner, let me see if I could kind of zero in. Isn't basically the crux of this case is whether the change to the judgment constitutes the correction of a clerical oversight or a substantial change involving a mistake in the judicial judgment? Isn't that the bottom line, the issue facing us right now?
Mostly that's where the issues lie, but more importantly, I think for the court to consider and think about is it wasn't just something that was as simple as a clerical error. This wasn't a property address that was put in wrong. It's not that the address should have been 100 and instead the judgment says 10.
And I appreciate that that's your position, but how do you, and help me out, how do you reconcile the substance of the final judgment, making very specific findings of, I guess, lack of better word, fraud on behalf of the former wife, with the term use and possession? I mean, obviously, if you look at that final judgment as a whole, there's a disconnect there. Don't you agree?
Well, I don't really agree, because if it was this in court, if it was the trial court's intent, the original trial judge's intent to award a property to the former husband solely as a result of some sort of egregious misconduct or something along those lines, there are statutory requirements that would have had been put into the judgment with very specific findings. And the court did not make any of those findings that would explain or justify any such unequal distribution at that time.
But didn't the judge also, though, in the final judgment, basically did not find the wife credible, went through very specifically some of the things that she has done in terms of alleging that that was a signature of a notary, where the court found that that was not the case? I mean, that was pretty damning type of, language in the final judgment. And so that's the question that I have, is that very clearly it appears that the final judgment intended on giving title to the former husband. And why is that not simply a clerical mistake, which is like either omission or something within and under the rule, the family rule of 12.150?
Well, if it were simply a clerical mistake, here's the issue that is an important one for the court to understand. We're not just talking about one property that was part of this alleged error. There was a property with no allegations, no findings, no evidence presented at the time of trial, or specific findings raised in the judgment that said that former wife shouldn't have had another property, or there was some question or anything like that. But the issue.
Go ahead, Ms. Liner. I have a
Well,
question.
just really briefly with that is just that it was not, there was another property too. So it's not just the singular property that had questions raised, but regardless, if it was the court's intent to say that deed was fraudulent, say anything of that nature, there's still not that sort of finding to reverse the deed effectively, which was the relief that was really sought by presenting all that testimony at the time of the trial, there wasn't any of that language included in the judgment. So it just went through all these findings about credibility, but then ultimately said, okay, we're dividing the properties.
Well, as I read I don't think you can, if you read this final judgment, I don't think you can conclude other than these two properties were the separate properties of the spouses. That the alleged transfer of them was from the sole title to joint was fraudulent, and the change here seemed to me to be like unnecessary. The court left the property in the ownership of the two parties, and purported to award them exclusive use, but it didn't find that they were marital properties. It seemed to find just the opposite.
I would dispute that a little bit with regard to it actually referred to the one parcel as the marital residence. An important factual.
That doesn't mean it was marital property.
But here's the important detail, is that the marital residence also included a marital dwelling that was put on the property during the course of the marriage. And the judgment doesn't separately distribute that property. And why that's important is if we were talking about a fixed brick and mortar home, that would have presumably gone with the property. However, we were not talking about a fixed brick and mortar home. We were talking about, I believe it's a triple wide, but a modular home that has titles that weren't retired, aren't affixed as part of the deed, and it didn't do anything with regard to the adjudication of what should occur with those. So the intent with the equitable distribution was to simply say this parcel's husband's, this parcel's wife's, and everyone moves on. Then we're lacking the distribution of a marital asset. That was
indeed, and your side could have asked for a rehearing or appealed on that basis, correct?
Correct. And just so it's clear for the record, we did move for rehearing. It was denied by the trial judge. We moved to vacate the judgment on the basis of these assets that were not distributed. That was denied by the trial judge, or a subsequent trial judge, not the judge who ultimately heard.
It was a senior judge, correct?
Correct. But it also, just so the court's clear, it was not the judge who ultimately ruled on this motion either.
Right,
it was the predecessor judge to the division.
Right.
But
So did your side appeal the denial of the motions, post-judgment motions, motion to vacate and so forth?
we did not, and here is why, because ultimately, at the end of the day, the parties then held the properties in joint names. They were tenants by the in common, and they each had ownership, interest, and rights. Though the husband had exclusive use of one and the wife had exclusive use of the other, ultimately, that was the effectuation of the equitable distribution.
What do you make of the suggestion that the question of how title was held or how ownership was held was actually left sort of ambiguous by this final judgment?
I don't agree that's the case, and I'm going to cite to a long-held precedent by the Florida Supreme Court in the Davis case. We've held for more than 35 years, if a court does not expressly distribute the ownership interest, and in the Davis case, the wife had been awarded possession of the home, but the court did not adjudicate the ownership interest. And despite numerous attempts of trying to modify that post-judgment, the Florida Supreme Court said no. The bottom line is, if the court could have adjudicated that at the time of the final judgment, and they chose not to do it for whatever reason, and it wasn't done, the property is now held by tenants in common by operation of law, just the conversion from tenants by the entirety to tenants in common upon the dissolution.
It assumes, though, that these deeds to the parties as tenants by the entirety were good, and every finding in the final judgment suggests otherwise.
It raises credibility issues, but recall, and I don't see any factual finding that expressly asserts that the deeds themselves were fraudulent, should have been vacated, should have been dissolved, or even the express finding that this parcel was wholly former husband's and there was no marital interest, because regardless, even if, for argument's sake, even if the court had found it was initially former husband's parcel, the wife had still asserted, and the court did not address the marital contribution with the home that I'd already talked about. And I think that's a very—
This was not a brick and mortar home. So is the triple wide, is that improvement to real property, or is that registered like as a mobile home, like a vehicle?
Well, this one, as far as I was last aware, the titles were not retired to be part of the property. I'm not sure if the former husband has taken any subsequent action, but I can tell you at the time of the hearing it.
Triple wide is personalty, not realty.
Correct. It's the best case scenario is you retire the titles and you affix it to the parcel, but it in and of itself could still be as a separate item. But regardless, that was part of the parcel that wasn't distributed. And in my experience and from my understanding of how this should have worked, if that was the intent to treat that trailer as a separate item, it should have been adjudicated as such. It should have been.
And it's interesting, Ms. Lyon, because here we have a very unique factual scenario where the actual presiding judge that prepared that final judgment testified. And so if you look at, let's look at for family rule procedure 12.540, and basically very clearly it says clerical mistakes in judgment or other parts of the record arising from oversight or omission may be corrected at any time on its own initiative or by any party. And here you segue, and if you look at the actual hearing where you have the actual presiding judge testifying and stating, this was a mistake. I needed to say title as opposed to use of possession. So how do this is what's before us right now, where you have someone saying this was a mistake, clearly mistake, was unrebutted. There was no contrary evidence provided. Why can't we just simply accept that and agree with the trial court below to affirm what he has done?
Well, the very important issue is that Judge Wilhite had the opportunity to correct her error if it was an error. There was a motion for a rehearing. Simply, if she thought there was a question, she could have herself requested a hearing on that, amended the judgment at that point, because she clearly had to look at the judgment to determine.
And I appreciate that, but this rule doesn't say it has to be done within a reasonable time or it has to be done within it. There's no time limitation on this. So this rule basically contemplates that, hey, it could be, and right now we were up to 3 years later.
And here's where I think we can, and again, it's very fact specific and very nuanced case, but the issue is the trial judge on her own didn't take such actions. When they were pointed out to her, she ignored to take any action, in fact, declined to take any action. And even when asked at the hearing, independent of whether it was error or not to allow her to testify, she still acknowledged that she had no independent recollection of anything with this case. And
well,
even as
it's not exactly accurate. She said that she did remember this case.
No, that's what Mr. Townsend says. But then when I asked the question, if she remembered the case prior to being contacted by Mr. Townsend, and she said no. And it's later in the record because the court effectively denied my request of voir dire the witness prior to her testimony, and says that let me ask the questions on cross. And she did not have independent recollection. She did not recall the motion for rehearing. She didn't remember the parties. And I think that's a very key.
She remembered the case. She said that this should have said title rather than occupancy.
Well, she said that's more of a what she should have done, but she didn't expressly state anything that she remembered. And she even testified that she did not remember the parties. And if there was such a factual concern of credibility of a party or anything of that nature, she would have or should have remembered that. And it's more of a what she stated was a what she should have done, not what she didn't do, not why she did something different in this case, in these circumstances. And that's a key distinction, because even if we go back to one parcel was marital to the husband, even if we take that fact as true, or I'm sorry, premarital to the husband, even if we take that fact as true, if the court's intent was simply to equally divide the parcels, and those are the words that are used in the judgment, then that wouldn't have even been an equitable remedy, because then wife got one property solely without the husband then being awarded any marital interest and an equitable distribution, because his non-marital property, if for argument's sake it was non-marital and it shouldn't have been considered, then the court should have addressed the equitable distribution with regard to the other property with either a finding of unequal distribution and laying out the statutory requirements of unequal distribution.
Well, I get that, but so aren't you making an argument here, Ms. Liner, about the credibility of this evidence versus the fact of the evidence? This judgment, is lacking in a number of ways, but that doesn't alter the fact that the issue presented by, I guess, was this judge, I won't recall which judge this was below, but was whether there was
It was Judge Moody.
Whether there was an error in this judgment that was correctable under 12-540.
And I would assert, and shockingly, there is not the case law that I thought would be on this issue with regard to what counts as a clerical mistake when we're changing the title. But the one case that I could find on point was Keller out of the 3rd DCA that said, if you're changing title, ownership, that's not a simple clerical mistake. That's not just a oopsie. I believe the word they used was slip, but I understand that. And I understand that this case, sort of on the line between a purely clerical and a more substantive change. But if the judge was of the view when she entered this judgment that the title was ownership was in the respective parties, not joint, then using the word title was not a change of substantive change. It was a correction of a misstatement. But that is the issue with regard to the second parcel. The Bullfrog parcel was clearly in joint names. There was no dispute as to any deeds executed related to it. And that parcel was held in joint names. So by operation of law, so that was what the court's intent had been to do, then again, we're still back to this one parcel that maybe there's a question, maybe the court found that it really shouldn't have been in joint names, but regardless, we have another parcel that has no such dispute, no such questions, and the court does not choose to take any action to adjudicate ownership of that parcel. And that's what's important, because that parcel, the court would have had to adjudicate, because then we are back to this question.
But Ms. Liner, that wasn't before the court. That wasn't brought up. I mean, you would have, if it was brought up before, but that's not what we're dealing with here. We're dealing here with simply to follow what Judge Northcutt said, is that if the court had intended, and we have testimony from the trial court, which is again rare, to say, this is what I meant to do, that's the concern.
But and I would say that if we had a judge that remembered and really remembered the parties and remembered the case and remembered the evidence. And that judge said, yes, this is 100% what I meant to do in this case, not what I think I would have done. And that's just it. If we had
But that's not, but if you look at the transcript, that's not what the judge testified. At the beginning, maybe right before, said before Mr. Townsend reached, she didn't remember, but then she very unequivocally indicates she does recall this is exactly what she wanted to do. So I read it differently. I think it was pretty straightforward as to her testimony. Her testimony seemed to be very clear as to what her intent was, and basically acknowledging that it was a mistake.
And if that truly had been her intent,
well, help me out. We look at the transcript, we're reading at the same sentence. Where is there? Show me where in this transcript that indicates that this was not her intent.
By her denial of the motion for rehearing on these very issues before.
No, ma'am. I'm talking about at the transcript, at the testimony. I'm not talking about before. I'm talking about this one here. Where is it? We have an evidentiary showing with testimony. Where in her testimony did she say that her intent was different from what she testified to?
And it's not there because but that's the important thing. She did not remember factually all the details. So it's not in the transcript. It is not in the transcript. I will concede it's not in the transcript.
It's Ms. Tanner, you are in to your rebuttal time.
I will yield to my rebuttal time and I will reserve.
That works. Okay, Mr. Townsend, you're up.
I'm afraid to say anything for fear of overcoming what the court has expressed. I'm being facetious, but honestly, I think it's obvious what the court intended. And she did not participate in a re-evaluation, which may have required a different type of approach under the rules. And I just think it's obvious what happened here, and that the court ought to uphold the change. That's what the court originally intended, and there's no reason not to affirm.
Now let me and point out, and you guys correct me if I'm wrong, but as I look at the order that we have on appeal here, that order changed exclusive use and possession to title in as to both properties, as to paragraphs Roman numeral 3, paragraph 2 and 3. Correct? I mean, it did.
That is correct.
Okay. All right. So nothing further, Mr. Townsend?
No, I'm done, Your Honor.
Okay. Sometimes that's the greater part of valor, as they say. Okay. Ms. Liner, to rebut.
What is so important for everyone to understand, though, is the timeline on this. And so we're clear, it wasn't a motion to amend. It wasn't a motion to correct Scrivener error. It was literally entitled a motion to modify.
But the title of the motion doesn't control. It's good. There's a lot of law that says that it's the substance of the pleading or motion that controls its nature.
And importantly for the court to consider, Mr. Townsend's motion did not seek to do anything with regard to the Bullfrog property. He sought to modify solely, and again, if the intent of everyone had been for the Sykes Road property to be deemed as Mr. Martin's sole parcel, has his non-marital parcel, the court, Mr. Martin's motion didn't seek to do that. It didn't seek to say, wait, court, you got this wrong. It ultimately didn't seek the relief that was ultimately ordered. But more importantly, then I come back to, we file a motion to modify. We have the appellee had all the time in the world to file a properly timed motion for rehearing, to seek to vacate within a year. If the court got it wrong and deemed and distributed to him as equitable distribution, his non-marital parcel, but he didn't seek to do that. He waited. He waited until more than a year after the judgment became final. And it's not a simple Scrivener's error. That's, I think, the important thing that, if nothing else, for this court to consider of what really is a clerical error, what is a Scrivener's error.
And I guess that's the bottom line, Ms. Liner, that if we come to the conclusion that this was a Scrivener's error or an omission or a mistake, you'd agree that there's really no timeline under the family rule. You'd agree with that, correct?
I would agree that there is no set timeline because it's basically a reasonable standard is what would be equitable. But the issue in this case, and
You have a tough spot that you're in. It's very unusual to have the judge who entered the judgment under oath and say, this is what I meant. I mean, how do you combat that?
well, if nothing else, the court can clear.
The family law judge said, I made a mistake. I'm here to correct it. I don't know I don't know what you do with that other than say, tip your hat and move on.
Well, I think part of the thing, as you all are clearly aware, is that she was not a fan of my client.
Yeah.
The original judge was not a fan. And so for her to say, yeah, I'm not going to do this thing that's going to help this lady that I clearly didn't like, even though she says she doesn't remember the parties independently. So
well, I was a family law judge, as was Judge Kazan for a while, and you don't remember names necessarily. And Judge Northcutt had probably as much experience as both of us together in family law. But once you start talking about the facts of the case, it comes right back to you in all its splendor.
But I think that's the important thing too, because regardless, the court, it couldn't have just been an error, because one thing that nobody talks about wasn't part of this motion, but there was, independent of the trailer, there was a whole other piece of real estate that wasn't distributed by this judgment. Now, there are some practical reasons why we didn't move to address it, but ultimately, there was lots of things that if they had been Judge Wilhite's intent to correct and she desired to correct, she had ample opportunity.
Sure.
And she chose not to. And Judge Fuson, who was the judge who addressed the motion to vacate prior to Judge Moody taking the division, he instead denied the motion to vacate, the timely filed motion to vacate the judgment on these issues, these failure to distribute issues, basically because his position was the properties were held. They were now tenants in common, and they were distributed how they needed to be. Because if that issue had never been raised or a subsequent judgment, ultimately, and I believe that is what truly did trigger the appellee's much later in time motion to modify, is he realized he couldn't do anything with property without his former wife's consent, because they did join it all.
Okay, your time is up, Ms. Liner. Thank you both very much.
Very much.
Thank you.
In order to leave our courtroom, you click the leave button that is on the Zoom screen and you'll be done.
Good day, Your Honor.
Thank you. Thank you both.
Have a good day.
Bye-bye.
And with that,
All getting out.
we're adjourned.